welcome back to the channel. So this brief talk is going to cover some of the misunderstandings with the law on being unfit through drink or drugs and being in charge of a motor vehicle whilst above the prescribed limit. And there's a reason that I separate the two. And that's actually the reason for the video. Because many people will be familiar with Section 5 of the Road Traffic Act 1988. Whether you're familiar with the exact wording of it or not is kind of irrelevant. But you'll be familiar with the point that driving or being in charge of a motor vehicle with alcohol concentration above the prescribed limit is an offence if you're in charge of the vehicle on a road or other public place. And within that section, there is a defence that many people might be aware of, that it is a defence for a person to be charged with this offence to prove that at that time he is alleged to have committed the offence, the circumstances were such that there was no likelihood of his driving the vehicle whilst his proportion of alcohol in his breath, blood or urine remained likely to exceed the prescribed limit. So in the standard run of things, if you are over the prescribed alcohol limit and you are in charge of a motor vehicle on a road or other public place, then by default you are going to be guilty of this offence, unless you can raise and show the defence that there was no real likelihood of you driving the vehicle. Now, it's not sufficient to say that you were asleep on the back seat, therefore there's no likelihood of you driving the vehicle. It may be much more of a defence if you have, let's say, a camper van and you are definitively camped for the evening with your family. It's a camper van, that's what it's for. There's no real likelihood of you driving the vehicle. However, it is still going to be down to you to prove in the precise circumstances that this is a defence to you. But that aside, as the standard starting point for this video, that is just talking about the prescribed limits. Now, if you recall, I opened the video by talking about being unfit through drink or drugs and by being in charge of a motor vehicle over the prescribed limit. Now, being unfit is actually dealt with in a different section. This is very closely related and it's dealt with in Section 4, which is immediately before the section for being over the prescribed limit. You see, Section 4 is a very powerful section of the Road Traffic Act that police can use. You see, Section 4 is driving or being in charge when under influence of drink or drugs. A person who, when driving or attempting to drive a mechanically propelled vehicle on a road or other public place, is unfit to drive through drink or drugs, is guilty of an offence. So let's break that down very slowly and very carefully, because this is very powerful and it may catch lots of people out, because lots of people may rely on the limits and know the limits of what they are consuming as against what the limits are in law to drive a vehicle. Now, let's just be absolutely clear for one moment. My strong suggestion to everybody watching is if you are going to drive, then don't drink. It really is that simple. However, for those of you that do have a drink and then you go on to drive hoping that you are under the limit, this video is primarily a warning to you, because Section 4 does not talk about limits. Section 4 talks about being unfit. Now, that depends on lots and lots of different things, and it most certainly doesn't depend on or is limited by the limits prescribed in Section 5 for concentration in breath, blood or urine. So let's talk about this a little bit further. So depending on your physical makeup, that being your age, your weight, your fitness levels, your metabolism levels, whether you have eaten that day, whether you have eaten immediately beforehand, whether you've eaten after you've had the drink, or how long it's been since you had that drink. For example, somebody who is potentially very unfit but very slim and hasn't eaten and has one shot of very strong whiskey, then gets into the vehicle to drive, that person may well be unfit to drive after simply one drink, and in which case they would be guilty of an offence for being unfit to drive through drink under Section 4. So if they were to get into the vehicle and they were swerving and they happen to be stopped and they are confirmed to have alcohol in their system, albeit not necessarily above the prescribed limits, but if it is deemed to be the case that they were unfit to drive because they had alcohol in their system, then they may be guilty of this offence under Section 4. Now, looking at the punishments, if you are found to be guilty of this offence, again, as many other offences, there's a Category 1, Category 2, Category 3. And the starting point for category 3, the lower end of the scale, is a band C fine, which has a starting point of 150% of your weekly relevant income. However, if you are placed into category 1 for the level of seriousness for this offence, the starting point is 12 weeks custody. And there are a number of things that can determine whether this is a category 1 or not. Typically, higher culpability and greater harm. Not to mention there'll be a significant disqualification period. The typical factors indicating the higher culpability would be driving a large goods or heavy goods vehicle or passenger service vehicle, or driving for hire or reward, such as a taxi. Whereas there are, of course, lots of other aggravating factors that might come into play here, and the court is going to take each and every one of those into account. And going back to section 4 for a moment, there are two subtly different offences within this. One of them is driving or attempting to drive a mechanically propelled vehicle on a road or other public place whilst unfit through drink or drugs. The second is being in charge of a mechanically propelled vehicle, which is on a road or other public place, whilst being unfit to drive through drink or drugs, both of which are offences under section 4, neither of which rely on the limit which is specified for concentration in breath, blood or urine. And subsection 5 within section 4 provides, for the purposes of this section, a person shall be taken to be unfit to drive if his ability to drive properly is, for the time being, impaired. So this is all it really takes, that one single word, impaired. If your driving ability is impaired because you've consumed alcohol in any quantity whatsoever, if it results in your driving being impaired and you are either in charge of the vehicle or you're driving or attempting to drive the vehicle, two separate offences, then either way you are guilty of an offence. So remember, being in charge of a vehicle simply might mean you have the keys and the car's outside on a public road. So even if you've just taken your first drink, the car is outside, you know that you haven't consumed enough to yet be over the concentration levels to be guilty under section 5, which is usually what people think about when they think about being convicted for drink driving. Section 4 provides a much broader scope to prosecute you, even for one single drink, if, according to subsection 5, your driving is in any way, for that moment, impaired. So I do hope that this has been a little bit of an eye-opener to everybody watching, because there's always talk of the limits for alcohol being in your breath, blood or urine, but please remember that even a single drink can make your driving impaired. And so if you have a road traffic collision, not only is that going to have an immediate effect on your insurance, but if you are breathalyzed at the scene by police because somebody is hurt, then even the mere presence of alcohol in your system, whether over the limit or not, may result in you being charged under section 4. So I hope that was useful. Please subscribe to get more useful information like this. Please also remember to hit the like button, and as always, thank you for watching.